Speaking to, oh, you can use that mic. Thanks.
Good evening. Frederick Neiman, Helen Neiman, Brian Freehold, on behalf of Arthur Allmuller on 106 12th Avenue.
And can you spell his last name, please?
A-U-M-E-R-M-U-L-L-E-N.
A-U-M-E-R...
M-U-L-L-E-N.
Okay, and Mr. Neiman, while you're here, I understand that you had some issues about the notice, and if you could briefly just relay what your initial concerns are, and then I'm going to give Mr. Shipers an opportunity to speak.
Yeah, Mr. Chairman, I had raised the issue with Mr. Shipers last week as a professional courtesy. The general rule is when you make a substantial change to an application before a board, you have to renotice and you have to resubmit the plans and have them before the board secretary at least 10 days so that if any member of the public wishes to inspect the application or the plans or the exhibits, that they have at least that period of time to do so. Now, I know that the applicant has made modifications, or at least it's my belief, based on some discussions I had with the applicant's attorney. So I had suggested that perhaps it would be more advisable to renotice because he is making a substantial change, and to my knowledge, nothing has been submitted to the town, and therefore I had had a discussion with Mr. Kennedy today also concerning the issue of notice, jurisdiction, all that, because the worst thing you could do is spend X number of meetings hearing an application, approve it if you choose to approve it, have me go and appeal it on what lawyers love to do, you know, those technicalities that everyone hates lawyers for. And then I win on a technicality, then they're back here in front of you again and you got to do it all over. So that's the issue I raised. I didn't want to blindside Mr. Shipers with it, gave him advance notice of what I would be saying here tonight, so I've said my piece.
Thank you, Mr. Neiman. And Mr. Shipers, did you want to make any additional any comments on that?
Yeah, yes, I do.
And I guess just for the record, introduce yourself and your appearance.
Yes, Mr. Chairman, ladies and gentlemen of the board, good ladies, gentlemen of the public, of Belmar, and other places of New Jersey and wherever else you may have come from far and wide, last time and this time, so we could get this thing moving. One, I thank you for coming that time and this time. We had submitted plans, we had noticed, we were here last time, ready to go to special session, which I thank the board for taking last time and scheduling for us. Because of a quorum issue, it did not go. And Mr. Neiman, wherever he went, Fred, thank you for the heads up. You're a straight up guy that gave me notice of your concern. Mr. Chairman, as you know, routinely over at least the 20-25 years I've appeared before this board and other boards, we present applications. Routinely, you have a question, and maybe even tonight, when the other applications are on, you're going to say, can you pull the building down 2 feet? Can you move it in 2 feet? Mr. Capaldi always says, can you put the electric underground? Ms. Casserly might say, can you put brick pavers? Mr. Fitzgerald might say, I can't remember if Fitzgerald is right now, but he'll have one perhaps. And we agree, or we disagree. We don't submit change of plans all the time, but Mr. Kennedy makes them a condition of approval if approved. Far be it from me, when I'm a principal in an application, to try to do more. Because you know what happens when you do more? I listen to the concerns of as many of the people who took me out on staying last time. I listened to the blogs, good, bad, indifferent. I hate you, Mr. Shipers. I wish you were dead. I wish those would stop. Because my family's more concerned about them. I'm not. But I listened. So I made changes. It wasn't a big change. I took the top off and I brought it down to try to accommodate. So I submitted plans that you would have and we could show tonight and move forward. But I understand Fred has a job to do. He's made it clear, Art has made it clear, there's going to be appeals no matter what happens if we're successful. I don't want to have to do it over again as well. I want to go forward. The public wants to go forward. They don't want to come back. Well, it's going to go forward.
No, don't speak for us.
I will submit then to Mr. Kennedy's arguments and recommendations, but this will go forward. Thank you.
Okay, so we've got a couple of things. So I'm sorry, Mr. Shepard, did you want to proceed tonight, or?
We're here, but
Okay.
if there is a concern about
Okay.
appeals and appellate records and additional costs borne by the borough, I have a concern for that.
Okay, and I appreciate that. So,
Mr. Kennedy, I have another concern, and that is that we didn't receive plans beforehand. I didn't. I don't know if any of the other board members did, but we didn't receive revised plans
Okay.
before this meeting, and that does concern me. I'd like to see what, we usually have a few days to review them in detail and those kinds of things.
So what we do, we have a couple of things, and I'm going to speed read, just because I figured with so many eyes looking at me, I probably wouldn't recite things off the top of my head. But, so we have really a legitimate issue here, and I guess at the heart of this is Mr. Shipers is making an application and making a modification which he feels is going to be a better application, a more compatible application, or a better zoning alternative for the borough of Belmar. Now, whether you all as board members or the public agree with that, that remains to be seen. But you certainly don't want to penalize and make it hard for people to make more conforming applications. That's something that we generally want. But we have two different opinions from two very respected members of the bar, two learned counsel, and it's a tough decision. So let me speed read through my little speech here. It's only 30 pages. It's much quicker, but I want to make a record. So let's see. We have some important procedural issues to make relative to this process, and I'm not even talking about the important substantive issues that you're ultimately going to have to make. But the decision that we have to talk right now is a procedural issue, and it is very, very important. So notice is always important. In fact, the axiom that we always usually deal with when we're really reviewing the case law, it says notice is jurisdictional. And what does that mean? It means that if we as a board don't find the notice is sufficient, and doesn't comply with the prevailing requirements, we as a board don't even have the jurisdiction to substantively rule upon the application. And that's a pretty daunting scenario, and yet it's a scenario we deal with on every single application. One of the first things we do on every single application is we look at the notice, we ask if anyone has concerns with the notice, and then we say that April and I reviewed the notice and found everything to be in order. And likewise, in every single resolution, including we have 2 or 3 resolutions tonight, one of the first findings of fact says that we as a board find that notice is sufficient and notice complies with all the prevailing requirements. So it is very important. The purpose of the notice, obviously, is to advise the public in general and the surrounding property owners about the development application, and that the applicant has submitted an application and that they have a right to comment on it, they have the right to attend the hearing, they have the right to ask questions, and all those great things. To bore you, but just for the sake of full disclosure, by law, the notice has to have generally 4 things: the day, the date, the time and place of hearing, the block and lot and the street address if there is one, the nature of the matter to be considered, what are you doing, and when and where plans are on file and available for public inspection. So, and as everyone in this room will attest, members of the public look at these notices, and sometimes they get it, sometimes they get enraged by it, sometimes they're happy, they say, how come they even notice me, and how come I had to go to the mailbox and post office and sign for a certified mail. But basically, the intent of these notice provisions is that when the public gets this notice, they can say, okay, I'm okay with this, or I don't really care about this, or, hey, I really would want this thing approved, or I would really want a condition on here, or I really think this application should be denied. And sometimes they'll say, I don't care enough about it, or they'll say, I think I need to go to town hall and look at these plans to get a better idea. And people routinely will come into April. So the notice, as you can imagine, is quite important. So let's look at some of these issues that we now have at hand. The notice that Mr. Shipers provided, which at the time was absolutely perfect, said, you know, what he was proposing and the height and the level and all those things. And then obviously it changed through his June 20th, 2018 letter that he was going to make some changes. He was going to reduce the height and he's going to lose that top floor. Probably would change the floor area ratio. I'm not sure on that. So those revised plans are clearly different from the initial submission. And I'm not saying it's better, I'm not saying it's worse, but it's different. And I think everyone can agree upon that. We can agree upon, or agree to disagree on how material those differences are, but it's different. So that's number one. Now, the decision is much easier to make when the revised plans make a proposed building taller, or more dense, or more apartments, or more parking spaces. That's easy. You absolutely positively have to renotice in those situations. So we would say something like, if the initial application was they were going to have a height of Y, and then they changed the height to Y plus X, clearly there'd be renotice in that situation. Because members of the public would be rightfully thinking, I got the notice, it said it was going to have a height of Y, and now it doesn't, and had I known it wasn't going to be Y, I would have come and yelled, or I would have called and asked questions. So that's an issue. In this situation, it does not appear that, at least in the most obvious sense, that this is a more intense application. It does not appear that it's more dense or higher. Rather, it seems less intense, smaller, and more compacted. So that is an interesting twist. And I am not, at this point, sure if, to be totally honest, if legal notice is technically, or renotice is technically or legally required. But certainly, an argument can be made that renotice should be issued simply because the revised plans are, in fact, different. And out of an abundance of caution, in my opinion, most applicants under these circumstances would probably say, I don't want to deal with the potential for a threat of a procedural issue. I don't want to deal with what Mr. Neiman just said about having a lawsuit to deal with the procedural issue, and they would probably just renotice. So next issue, and Mr. Neiman raised this, is pursuant to law, technically, plans are supposed to be on file 10 days in advance of a public hearing. And the law recognizes those 10 days as a sufficient time in which the public is authorized to come in and take a look and check out those plans. So clearly, throughout the long zoning board process, the applicants always have the right to come in and look, but technically, the law requires that plans be on file 10 days in advance. So respectfully, I do not believe that these revised plans have been on file 10 days in advance, and that could be a procedural issue or a procedural question. Next up is, I do not believe our zoning officer has yet had an opportunity to review the revised plans so as to ascertain if there's any different variance relief necessary. I don't know if there is, I don't know if there isn't. And if they might be different, might be less intense relief, but it's sort of, as I said here, with all these eyes looking at me, that's why I wrote out my little speech, it would probably, and I don't want to speak for Ted, my friend and the zoning officer, but probably not fair to have him look at the plans in the middle of this meeting and say, hey, give us a ruling. Likewise, I do not believe our borough engineer, acting as our board engineer, has yet reviewed the revised plans, and this is an issue. As such, our board engineer's review memo, which is all in front of you, is basically based on rather outdated information. And next up, I really am bringing it home here. At the risk of overstepping my bounds, given the nature of the application, the nature of the opposition, the amount of public interest generated in the project, and quite frankly, the number of attorneys in the room, I think we have to be reasonably anticipate that there's a strong likelihood that there will be litigation associated with the board's ultimate vote, whether the board approves the application with conditions, or denies the application. So knowing that, I think that we have to be extremely sensitive to comply with all procedural requirements. Again, I hope that there is no litigation, but I think we have to basically be realistic that every procedural decision we make, including this decision, I really have to think in the back of my head, well, what is a judge in Freehold going to be thinking about this? Is a judge going to like what we've done and find that it makes sense, or is a judge going to find that it's a little arbitrary or a little odd? So incidentally, I know there are many people in the room tonight, and I just want to say, and this is very important, that the reason I respect this board so much is, and the reason I respect the board members so much is because you all treat every single application like there could be litigation. And as a zoning board attorney, that makes me very, very happy. So even if it's an application for, quote unquote, just a guy who wants to put a deck on, or whether someone wants to subdivide a property or make a two-family home or whatever, you all comply with a bunch of procedural norms. You have me officially mark things into the record. You have me officially always review the notice and confirm that it's okay. You have me swear in our board witnesses. You have me swear in members of the public. You have me, we allow for direct examination and cross-examination, all those things. And we do those things because it's the right thing to do. And I always, if we do go to court, we want to be able to say we always did the right thing. So admittedly, the process is sometimes agonizingly slow, but that process has served us well, and respectfully, no reason to regress from that process. Now, going back to the litigation risk, in the event that there is litigation under New Jersey law, there is a presumption that you all, as board members, know the community better than anyone. That you all, as board members, know what's going to fit in with the community and what's not going to fit in. And so against that backdrop, there's a legal presumption that whatever decision you ultimately make, that there's a presumption that your decision is going to be valid. Though the presumption is clearly not absolute. The idea is that there is a concept that that you all know the community better, and your opinions should count more than the court, and the court would only get involved to disturb your decision if it's arbitrary, capricious, or unreasonable. Those are the three standards. However, I submit that the presumption of validity really starts with and only really comes into play if we confirm and prove that we're complying with all the procedural norms. In the event the procedural issues are compromised, that presumption of validity may evaporate as well. Next up, in the event there's litigation, and Mr. Shipers just referenced this, and I appreciate this because this was a gentlemanly thing to say. In the event there is litigation, litigation is always timely, it's costly, it's expensive, and it's stressful. And in the event of litigation, whoever or whichever side does not like the ultimate answer that you ultimately give, they are going to institute a suit, possibly, and they are going to question and challenge every single decision that we make, including this decision. Every decision regarding whether I let someone from the public speak about evidence that is irrelevant or hearsay or beyond the scope of direct testimony. So there's going to be a million issues, so we try to minimize some of the issues. So I've been somewhat facetious here with regard to the litigation process and people challenging every single decision, but it really is not unusual for everything in the kitchen sink to be thrown in these litigation cases, and we have to go through and defend each thing. So against that backdrop, out of an abundance of caution for the second time I'm saying tonight, most board attorneys simply do not want to start an extremely long proceeding or a complicated hearing process with this procedural issue. Most board attorneys under these circumstances would simply say, I don't want to have to deal with this in the court, let's just renotice that we never have to have this discussion again. So next up, when it comes to notice, courts are pretty inclined to say and hold that substantial compliance with the requirements does not constitute or does not equal total compliance. So with the notice situation, there is a there's a challenge, and the courts generally don't like to be too loose with these notice provisions. And there is a possibility, and Mr. Neiman referenced this, that if there is litigation, that the judge could ultimately say, notice was deficient, so I want to remand this back to the Belmar Zoning Board to hear it in accordance with lawful notice. So though I like you all very much and I like being here, I don't think any of us would want to go through this hearing twice. So that would be another reason that we'd want to be out of, real cautious that way. One more note. I'm extremely sensitive, and I emphasize that, extremely sensitive to the timing issues of all involved. Let's just start in no particular order. The applicant's representatives are here. It's costing them money. It's costing them time. The objectors' representatives are here. It's costing them time. It's costing them money. And there's so many members of the public here, and their time is valuable too. I'm not unaware that they are not going to children's baseball games tonight, that they are having to have children be having babysitters, and they're missing dinner with their family. So I'm not insensitive to that. However, respectfully, those factors, though they are personally meaningful to me, that those issues don't really become relevant in this notice conversation. So I just sort of have to put my blinders on and look past that. Lastly, I am just the board attorney here. I have no substantive vote on this matter, and I only make legal recommendations. So to the board, my recommendations are just that, recommendations. And board members are certainly free to proceed how they desire. I don't get offended. We're still going to be friends. I'm still going to love working for the Borough of Belmar, but it's ultimately your decision as to whether or not you want to proceed. So in conclusion, with all of due respect to everyone in the room tonight, there are, in my opinion, significant procedural issues and questions as to A, whether notice is required, renotice is required, and whether the plan should be on file 10 days in advance, and whether or not it's a problem that board members and zoning officer and board engineer have not seen those revised plans. So I respectfully suggest that one of those issues in and of itself could compromise, perhaps fatally, any decision the board ultimately makes. And when we throw in there issue number 2 and issue number 3, it just exponentially exacerbates the situation. So Mr. Chair, Mr. Acting Chair, my position is that I would respectfully suggest that the attorney of record, and like I said, I appreciate that he is, as in his words, is making concessions to make this even a more appealing application. I respect that, and I think under the circumstances, I would respectfully suggest that we not hear the case tonight, that we require re-notification, and that we have the plans filed 10 days in advance, and that the applicant consent to extend the time frame within which we have to act. And I anticipate that there are some applicant supporters in this room who just want to get this thing done and over tonight, and I understand that. And I certainly anticipate that there might be some objectors in the room who just want to get this thing done tonight since we're all here and go on. But that, those timing sensitivities can't really be the basis. So against that, I turn it over to you for your review and discussion.
Okay, well, you can take a breath now. Well done.
Standing ovation.
I'll take it.
Thank you, Mr. Kennedy, for that very in-depth analysis of what we're faced with. Is it appropriate for me to ask the applicant's attorney, Mr. Shipers, to respond?
Sure.
I think I'll defer to Mr. Lonsky, my firm is going to co-counsel with him.
Thank you. Good evening.
Good evening.
Just a couple of quick points on the notice issue, getting a little bit more into the legal
Use the microphone.
Well, I'll try to
You can go to the microphone up here.
Happy to.
The microphone is really for recording this for legal purposes, and that's what we have to do.
Thank you, Mr. Chairman. Just a couple of quick points. One is that the requirement for notice is a reasonableness standard. Does a person reasonably understand that the applicant's seeking to take down the Belmar Inn and put up 24 condos? And I think everyone here knows that, and I think the fact that notice was sufficient is clearly evident from just looking around the room. Having said that, let me say this, that the most critical issue to the applicant in moving forward is the timing of this. And I would submit to the board that if you're inclined to ask the applicant to renotice and to make sure there's appropriate time frame, we would certainly request that there be a hearing date set, a special hearing date sometime in the next couple of weeks, so that everyone knows that the matter will actually be heard on that given night. This is, of course, the May meeting, there wasn't a quorum, it was adjourned. Now we're at the June meeting. We're just looking forward to moving this application forward so that the applicant knows whether or not to go forward and acquire the Belmar Inn and whether or not there's a project that's worth pursuing.
Thank you. Ms. Claudio, is there a date that we can settle on for another meeting?
We discussed the possibility of, for our regular meeting is July 26th. We already have a special meeting on July 12th. So the dates would be either the 16th or the 25th
So that would be 3 meetings in
July.
July.
What's the special meeting on the 12th? Yeah, what is that?
Just give me a minute to look at my calendar here. We already have a special meeting on the 12th, you say, and we have a meeting on the 26th. How does the board feel about another meeting for this month?
I'm fine. 7/12, 7/26, and you're proposing either 7/15 or
16th or 25th.
or 7/25.
And just so you know, Mr. Chairman, I think, just for the record, I think the July 26th meeting, this application is sort of already reserved too. So that's a very good thing too, that we have it on the agenda.
In case we need more time.
Oh, okay. All right. Would this special meeting would just be for this application only? We wouldn't put any other application on that meeting?
Correct.
Right. Okay.
Mr. Chairman?
Yes.
What was that date again?
The 16th or 25th.
I can't make the 16th, so I don't know if there's other board members that can.
I'm okay on the 25th if you can make the 25th. How many, Mr. Fowler? We can be
What day
available?
is the 25th?
25th?
Wednesday.
Wednesday.
It would be the day
Yeah.
before our regular meeting.
Yeah, I'm good on
Are we gonna get overtime paid? I can't.
There is no pay, just so.
Yeah, just so you know, we're all volunteers here.
No pay.
that. Speaking of pay,
I'm good for the 25th.
I'd like to know, come next year, is Mr. Kennedy asking for a raise, given this presentation?
No, sir.
Could I ask our alternates?
I'm available
Mr.
both dates. I'm available.
You're okay? We
And
can do
I
it.
checked with the chairman, he's available on both days also.
Okay, well, let's do the 25th.
Okay.
All right, so Mr. Chairman, if I may.
Sure.
So, 2 things. What we would do.
Please don't talk.
So if this is acceptable, what we would do is you would have a motion authorizing convening a special meeting on July 25th, 2018 at 7 o'clock p.m. for the purposes of the Belmar Inn application. And we as a board would serve a special notice just as required by the Open Public Meetings Act. And on top of that, we would announce that tonight so members of the public know this. And on top of that, Mr. Shipers and Mr. Lonsky are going to renotice everyone in the town's official newspaper and for the 200-foot list. And by all means, all the people here tonight will know this. So that would be, just another way of disseminating the notice. So against that backdrop, may I have a motion to?
I'll make the motion, Mr. Chairman, to move
Thank you.
the meeting.
Thank you,
to
Mr.
July
Fitzgerald.
27th.
I'll second it.
Thank you, Ms. Young. All in favor?
Aye.
Okay, and then last procedurally, Mr. Shipers, do you on behalf, or Mr. Lonsky, do you on behalf of your client consent to extend the time frame within which the board has to act?
We do, sure.
Okay, thank you very much. So ladies and gentlemen, please come back July 25th, 2018. There will be renotice.
25th.
25th. 15th, 12th.
We'll just take a short break while things move around here.
Okay, until they.